When a shareholder dispute arises, many directors assume the issue is strictly between the shareholders. That assumption is often wrong. Once a dispute is underway, directors can face real personal risk if they do not understand how their duties apply in a conflicted environment. In Victoria, directors' duties do not pause because shareholders are in dispute. In fact, the risk often increases. Directors are required to act in the best interests of the company as a whole, not in the interests of a particular shareholder group, even when pressure is coming from one side. During a shareholder dispute, this obligation becomes more complex, particularly where directors are also shareholders. Conflicts of interest can arise quickly, and decisions that might normally be routine can take on much greater legal significance. Common risk areas include restricting access to company information, excluding certain shareholders from decision-making, authorizing transactions that affect business value, or continuing to trade while the company's future is uncertain. Each of these decisions can be closely examined if the dispute escalates. Even decisions that appear commercially reasonable can be scrutinized if they disproportionately benefit one party or unfairly disadvantage another. Courts will look beyond intent and focus on the effect of the decision on the company and its shareholders. A common misconception is that following instructions from majority shareholders provides protection. It does not. Directors remain personally responsible for their decisions and cannot outsource their duties to others. Courts will examine whether decisions were made independently, in good faith, and with proper consideration of the company's interests. Emails, board minutes, financial decisions, and access controls can all become evidence once a dispute is underway. In some cases, directors may also face exposure for misleading conduct, misuse of company funds, or breaches of duty if actions taken during the dispute contribute to financial loss or unfair outcomes. Poor decisions made under pressure can have lasting personal consequences. This is why early legal advice is critical. Directors who seek advice early are better placed to manage risk, comply with their duties, and make defensible decisions in high-risk situations. At Pentana Stanton Lawyers, we advise directors and business owners across Victoria on their obligations during shareholder disputes. We help clients navigate conflict, protect personal exposure, and make decisions that stand up to scrutiny. If you are a director involved in a shareholder dispute, or tensions are beginning to rise, now is the time to understand where you stand. You can book a consultation with one of our lawyers at Pentana Stanton Lawyers to protect yourself before the risk escalates.